Read this page 3, peruse the application, just read from there.
Page 3.
Roman 3.
Roman 3.
Have you got it? Mr. Lalfaqjola, otherwise you read it.
I'll read it, my lord.
Yes.
Peruse the application along with annexer as well as the cited rulings. It is seen that cross-examination of PW number 1 was deemed declined due to absence of the learned counsel for accused applicant on 23/10/2023. The previous counsel did not make an application for recalling of PW number 1, and the present learned counsel also filed this petition on 19/3/2024. That is 3 months after he was engaged by the accused applicant on 18/12/2023. It is true that the inaction or negligence of the learned counsel should not prejudice the accused in his defense. However, upon perusal of record and also the deposition of PW number 1 and his seizure witnesses, it is seen that the accused applicant was apprehended at Zarkot by excise personnel using decoy customer and search of his residence pursued later on. And accused number 1 is his brother. Hence, the court opines that failure to cross-examine PW number 1 by accused counsel due to absence of his previous learned counsel is unlikely to cause failure of justice and no clash of interest.
This is what I don't understand. How can he decide? It appears that there was no cross-examination because of absence of the lawyer.
Yes.
Correct. So it would have been in the interest of justice to allow it. What is the prejudice?
That is up to the court, my lord. But
No, I am asking because you are also an officer of the court, right? You are the public prosecutor.
looking at the evidence, my lord, looking at the evidence of the PW number 1.
But you see, we will not be deciding the sufficiency of these evidence right now, isn't it? For a fair trial, these opportunities must have been given. Here is a case where it appears that the cross-examination was declined because of the absence of the learned counsel.
Yes.
So if today, if they on this application, if that was allowed, it would not have prejudiced anyone. On the other hand, it would have been a fair opportunity given to both sides. You would have also got your chances, isn't it?
And till now, prosecution evidence has not been closed.
No, therefore, I don't think there is any, it will serve any purpose by keeping this matter pending, by admitting. I think I can dispose of by allowing this. Right now, the order that you are looking for is, what is your prayer?
My prayer is at page 12. I'll read this, my lord.
This is your main prayer, isn't it?
Yes, my lord.
An order allowing recalling of PW1
Yes.
for the purpose of cross-examination. That is the prayer.
Yes.
So I'll allow that.
That is up to your lordship. But my objection is that the purpose is only to delay the matter.
See, generally, it is not necessary that in all cases of re-examination this court will allow. Here is a case where it appears that the counsel was not there. Only on that account. So therefore, there was no cross-examination. How can you deem the cross-examination?
And my lord, the interesting thing is that it was only mentioned in the deposition form.
And you see, it is mentioned, it is seen that cross-examination was deemed declined.
Yes, yes.
What is this deemed decline?
There is no
There was no cross-examination. The lawyer was absent. So I think in the interest of justice, for the ends of justice, we will allow this. All right. This is the order against which the revision is preferred, right?
9/4/2024.
Heard Mr. Item number 6. Heard Mr. C. Lalfaqjola, learned counsel for the petitioner. Stop. Also heard MS Linda, so and so, learned PP for the state respondent. This revision petition is filed under section 397, read with section 401 and section 482 of CRPC for against the impugned order dated 9/4/2024 passed by the learned judge special court, whereby the prayer for the petitioner for recalling of prosecution witness number 1 was rejected for the purpose of cross examination.
Only for the purpose of
For the
cross-examination.
purpose of cross examination was rejected. Stop. The facts of the case is that at Roman A of the synopsis, A to A. Okay. Mr. Lalfaq Jwala, learned counsel for the petitioner, submits that non-allowing the prayer of the petitioner for cross-examining PW1 has caused grave injustice to the party. Stop. MS par contra, MS Linda, learned PP submits that the prayer for cross-examination of prosecution witness number 1 is only to delay the trial. Stop. Heard the parties, peruse the materials available on record. Relevant portion of the order dated, this order is under challenge, 9/4/2024.
Yes.
Order dated 9/4/2024 is reproduced here under for ready reference. Roman 3 A to A. Okay. Apparent that the prayer for cross-examination of PW1 was deemed declined due to absence of learned counsel for the accused appellant on 23/10/2023. Stop. It further appears that later on the new engaged counsel,
Yes.
new engaged counsel made a prayer to re-examine PW1 for cross-examination only. However, by the said order, the said prayer was rejected. It appears that it appears in the context of the present case that rejection of the prayer of further cross-examination of PW1 has resulted in gross failure of justice. Stop. Accordingly, this court is of the considered view that in the ends of justice, PW1 in the ends of justice, the petitioner accused be allowed an opportunity to re-examine PW1, within bracket, just give the name. Where is the name of PW1?
Sidal Birtuanga.
Where do I get it?
81, page 81 of my petition.
81.
81.
Page 81, okay? Take the name. For the purpose of cross-examination. Stop. Accordingly, the revision petition stands. Accordingly, the order dated 9/4/2024 passed by the Learned Judge Special Court NDPS Act 1985 ISOL in criminal misapplication number 72 of 2024 in criminal trial number 1197 of 2023 stands interfered with. It is further directed that the trial court shall recall PW number 1 for the purpose of cross-examination. Shall I fix a date?
So I don't think that would be necessary.
Immediately upon receiving the records are here.
That's not been.
Immediately stop. Records are not here.
Not here. Deeply obliged.
Thus registry is required to inform the trial court about the order. Let registry intimate the trial court about the order passed by this court for
Deeply
doing
obliged.
the needful. Disposed of.
Order. Item number 8.
Who accused has already been granted bail.
Yes, Your Lordship, by the order dated
7/6/24.
7/6/2024, Annexure 4.
But co-accused, I think,
Mainly on the region mentioned in para 9 and 12.
who is, you are the driver.
I'm the driver. Your
You are the
Lordship.
driver. And who was the other accused who has been granted bail?
The owner of the truck.
Owner. And it was you who had implicated the owner.
Yes.
And because it was a statement of the co-accused, this court had granted bail. The owner was not inside the car.
Your Lordship, if Your Lordship kindly can kindly come to page 18.
1/8.
Page 18.
Yes.
Yes, this is the charge sheet, Your Lordship. The second last paragraph is about the alleged involvement of the co-accused who has been granted bail.
Yes.
If I may read, Your Lordship.
Yes.
Investigation revealed that Lalsang Asilo, son of Mang Tonga of
What
Ngur
is the
village.
name of the driver?
The name of the driver is Ming Tan Sanga.
Okay. Yes, please.
Of Ngur village, Champhai, Mizoram, was also arrested in the case as he was also involved in having common intention for transporting a contraband item, for heroin, to purchase on being requested by his driver, Meng Tansanga. He was interrogated and he stated that he purchased the seized heroin from
See, on being requested by his driver, that is you.
that is the allegation recorded in the charge sheet. Your Lordship,
Yes, but
he was,
you.
if I may come to the
But
next
one
line,
thing that you can't overlook is that this contraband articles have been seized from the vehicle which you were driving.
yes,
That you
Correct.
can't oversight.
correct, Your Lordship.
Yes, please read.
He stated that he purchased the seized heroin from one Myanmarese national, whose name he does not know, of Zokatar village. This indicates that this
You are making this court read about the second paragraph, but come to the deposition of the driver, of the petitioner. Accused person Himang Thang Sangha, that's the driver, correct?
Ming
Read
Tan
that.
Sang,
Let
yes.
us see what he has said. Stated that he was
He was approached,
Lal Sangha.
yes, by Lal Sanga of Ngur on 13/6/2023 to drive his truck 1109 to Aizawl. He readily
2
agreed.
bags of charcoal was carried into the hut and 4 packages each of heroin was kept inside the charcoal bags and was sealed again. So he admits,
But my lord, he does not know the contents of.
he has said it in his evidence. If this is his 161 statement, the
My
2
lord,
bags of
this-
charcoal was carried into the hut and 4 packages each of heroin was kept inside the charcoal bags and was sealed again. Lal Sangha told him to deliver the heroin packages at so and so. he will get rupees 50,000 from this delivery. On reaching so and so, they were detained by police. On being asked to take out any contraband drugs he was carrying, he took out the hidden heroin from the charcoal bags kept in the truck in the presence of civilian witness. The 4 packages contain 11 so and so, so and so. So he has already admitted that he has carried it in order to get rupees 50,000. This is his own
My
statement.
lord, what
And NDPS Act. Section 37 rigors is applicable in this case, isn't it?
Lordship,
Section 37 is attracted here. See, you have to confine to your case, right? Some other might have got it because there may not be any direct evidence. That is a different thing. But we have to confine to what are the materials available against this particular person, because this person has now approached the court for bail. Correct?
my lord, this is the statement made
Yes.
before the recorded by the police, which could not be relied upon for evidence.
No.
But my lord,
You see, we are now at this stage. At this stage, it can be. Anything more you want to say?
what I mean, I'm
Because I am
intending
not
to- My lord.
inclined. You see, 37(2), where the PP opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offence and that he is not likely to commit any offence while on bail. But from his evidence, it appears that there are reasonable grounds for believing that he is guilty.
My lord, what I'm trying to
Yes,
submit
please.
before this honorable court is with regard to the statement made by both the accused. The statement made by the accused, the present petitioner, is as such in the paragraph which we have just read. And the other accused who have been granted bail has also stated that he has purchased, it was alleged in the charge sheet that he has purchased this heroin from Myanmar, one Myanmarese. Then he instructed the driver to carry all the charcoal bags, including maybe that contraband drugs, to Aizol. So from the statement recorded from of both the accused persons, it appears also that the co-accused who has been granted bail has also involvement, mainly on the reason stated in para 9, page 62 and 63, Your Lordship. If I may read para 9 and 12, Your Lordship, of the order granting bail to the co-accused.
Yes.
That apart, no materials appears to be available in the case diary implicating the petitioner for the offense alleged. Prosecution has also not produced any material to show that the petitioner, if released on bail, shall flee from justice. No adverse material against the antecedent of the petitioner is also made on record. Same is the case with the present petitioner, Your Lordship.
No,
Order from
I'm
the
sorry.
same
Same
village.
is not the case because here you have admitted. You have admitted of transporting the contraband articles for 50,000 rupees, Mr. Counsel.
My
It's
lord.
your statement. At this stage, that statement is against you.
My lord, if
Maybe it might come up during trial. That is different.
My
But
lord.
right now we have to see whether there are sufficient materials implicating you or based on which reasonably this court can come to a conclusion that prima facie there is a case against you. I'm sorry. Yes,
lord.
Miss Linda?
My lord, the case is completely different. The other co-accused was released on bail because it was on the grounds of confessional statement of co-accused. And in this case, my lord, he was caught red-handed with huge amount of contraband articles, and it is proved that he was in possession and transportation of the seized articles. So the case is entirely different, and he cannot take the same.
You see, bail granted to co-accused cannot be a ground for
Yes, my
granting bail, provided everything is same.
My lord, if I may take your lordship to page 27. This is arrest memo, Your Lordship,
27.
27 of the petition.
Yes.
With regard to the co-accused who has been granted bail, this is Lelsang Asilo. He was also arrested on the same date,
Mr. Counsel,
14/6/2023.
you are not confining your case to yourself. You are only confining your case to what is the situation of the co-accused.
My
There
lord-
are clear evidence against you. You are not dealing with that.
My lord, that is one of my grounds for,
You first show me that you are innocent.
my lord.
Just because a co-accused has been granted bail doesn't mean that ipso facto this court will also in a routine manner grant you bail. You have to make out a case for yourself,
My lord.
isn't it?
Yes, my lord, I will.
So first do that. You are not doing that. You are from the beginning. You are referring to the co-accused. When this court is pointing you out the evidences which are available against you, you are not dealing with that.
My lord, I'm.
In fact, the submissions of the PP is also to that effect.
My lord.
Deal with your own case first.
My lord, my first point is that he is innocent of the allegation made against him. That is my first point. If I may submit my points, my grounds for seeking bail, my lord. The first point is he is the breadwinner of the family, and further detention would cause tremendous hardship to the family.
All
He is
that
the
is
father
not
of two
material.
children. my
All
lord.
right. I'm sorry.
Then, my lord, the second point is that he has never been arrested nor convicted of any offense before. That means
No history, Ms.
no-
Linda. No antecedents.
no
Nothing is written,
antecedents.
Okay.
It is recorded in the documents also.
You see, otherwise this court would have granted you bail, but 37 you can't forget.
My lord,
37 is in two parts.
I understand your
Have you
lordship.
are you carrying an NDPS?
Yes, your lordship.
Please read 37. Read 3:2. Sorry, where the public prosecutor opposes. Read
My
that.
lord. Whether the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit
So
any
there are
offense
two parts.
while on bail.
You see, there
My
are two
lord.
parts. One is about the prima facie existence of a case, and
My lord.
second, and suppose this court comes to a finding that yes, there is no prima facie case,
My lord.
then of course bail can be granted. But if the finding of the court is that there exists a prima facie case, then the rigor of 37 will come against you. And second part is the antecedent.
My
You
lord.
know, so here, because it has been taken from the contraband articles have been possessed from your possession.
Possession in the sense that it is seized from the truck.
Correct. You were driving the truck, and in your statement you have said it.
The truck was driven by me under the
Correct.
instruction of the co-accused.
Maybe, but in your statement you have said it that yes, I was carrying it. You have admitted. Sorry.
My lord,
All right. Now you please take the order.
My lord, if
You
I
are
may
Mr.?
if I may be allowed to complete my submission.
Yes. What more?
My lord, as I have submitted earlier, he has no past criminal record, and he is a permanent resident of Ngur village, the same with the co-accused who has been granted bail, and there is no danger of absconding from bail if granted bail, my lord. And the third point is that the co-accused has been released on bail. That is the next ground. And perusing the entire charge sheet, my lord, the prosecution fails to comply with so many provisions of the mandatory provision of the NDPS Act and the rules made under Section 52A. With regard to non-compliance of the 2022 rules, which is the narcotic drugs and psychotropic substances seizure, storage, and sampling and
What
disposal
rule
rules
has not been
2022.
complied?
My lord,
What rule has not been complied?
my lord, so many things have not been complied. My
Simply
lord,
saying so many things will
My
not
lord,
do, Mr. Counsel. Point it out.
my lord, I will come
Please
to that,
point
my
it
lord.
out. If a particular mandatory provision has not been complied, kindly point it out.
If I may submit this,
What is this?
this is the rule which I'm trying to say, Your Lordship.
Yes.
Rule 5.1, my lord.
What are these rules?
This is
Narcotic
the
drugs
rules.
and so rules 22. Okay.
This
Which
is-
rule? Rule 5.
Rule 5, my lord.
Deposit in Godam.
My lord. If I may read, my lord, the grounds that I have made in my petition. Ground number 7, my lord.
1 second. All seized materials referred to in sub-rule 1 of rule 3 after seizure under the act by the seizing officer in the nearest Gunam designated under rule 4 within 48 hours from the time of so and so. The time will be so and so. Provided that the set time period may be relaxed
My lord.
by further 24 hours. Sufficient charge Gunam before giving an acknowledgement so and so. Yes, now ground, page.
Page 5, Your Lordship. Page 5, ground number 7.
From where are you showing that this rule 5.1 has been violated?
My lord, as per rule 5.1.
That I have seen.
All the seized materials.
I have seen 5.1.
My lord.
Now show me from what document have you'll have to substantiate the ground.
My lord, as per these rules, all the seized materials should be, it is the mandatory duty of the seizing officer.
Where do you
It
read
should
the
be
word mandatory?
deposited by the seizing
Where do you
officer.
read the word mandatory from?
Shall. Shall is the word used.
So
Shall
if you are
means
reading the
statutory.
provision, read the provision. Don't read words which are not there.
My lord, I will read
Whether
with
the
the
rules
permission
are
of your
directory
lordship.
or mandatory, that is, we will look into it later on.
My lord,
But first show me. You see, Mr. Counsel, you are more anxious to show the rule. But what I am asking is that if there is a violation, you will have to show that in your case this violation is there,
My lord,
right?
my lord,
That
I'll
is
come
why
to
I am
that.
asking from which document you want to show that this rule has been violated. You
My
have
lord,
only shown me the ground in
there
your.
is nothing on the charge sheet to show that this rule 5.1 was
Complied.
complied. Form 1 should be used.
All right. Next ground.
Next ground is also Form 2. Form 2 is sub-rule 2, my lord.
Form.
Form 2. It
Form
is
2.
provided in Rule 5, Sub-Rule 2. The officer in charge, if I may read, your lordship,
Before giving an acknowledgement in Form 2,
my lord.
shall satisfy himself. So these are not there in the
These
charge
are
sheet.
not there in the charge sheet.
Okay, Form 1 and Form 2.
Form 2.
All right. All right, taken in a note of.
Then the next is Form 5, your lordship.
Form.
This is my ground number 9.
Hmm.
This is regarding inventory, your lordship.
Hmm.
The prosecution fails to prepare an inventory of all the seized material in Form 4, which should be prepared by the officer in charge.
So inventory also not prepared.
Inventory was prepared, but not as per the
Which
Form.
rule? As per?
statutory form.
As per? Which provision?
The provision is Rule 8, Chapter 3.
Rule 8.
He shall prepare inventory of such material in Form 4.
Rule 8, that is application to magistrate. Yes, Form 4.
Form 4 and Form 5 also, your lordship.
Okay, so this is also not done. Okay,
No.
next.
With regard to this violation of Rule 8, your lordship, I would like to submit before your lordship that it is the duty of the
All right, that I have taken
investigation
note.
to
Now, are you
to-
having
to submit all the
are you
photographs.
having any case law to show that Rule 8 and Rule 5 are mandatory? Any case law in support?
No case law, Your Lordship,
Okay.
as of now,
And,
because the rules say it is mandatory, because the
Okay.
word used in
All right.
these rules are shall, Your Lordship.
And
And
where from the charge sheet you want to show this inventory is not strictly in accordance with Rule 8? Which portion?
my lord, as per the inventory, all the seals, not only the drugs, and
Miss Linda, these things are available in the records,
No, my lord.
but it will be required
this is the charge sheet, Your Lordship.
here because there is an allegation that you have not, that the investigating officer has not complied with Rule 5 and Rule 8.
Yes, my lord. Rule 5 and Rule 8, my lord. I have talked to the IO, not this in this case, in other case, and I have been informed that they are following all these rules.
No, but that is only a general instruction.
Yes, my lord.
Since
And
an allegation has come,
Yes.
then you must show the
That-
quote from the record.
that can be seen in the trial, during the trial, my lord. For now,
No, but
whether they are
you
entitled
see,
for
even
bail-
right now, you don't have the case records, the diary.
My lord, charge sheet is already submitted, so we don't produce the case diary if it's already charge sheeted.
No, where is the case diary?
It's on submit sheet.
You will have to satisfy that, or otherwise, because I think these rules are directory. I don't think they are mandatory, but either of you must come up with some decision and show me that. So what you can do is, I can take up this matter tomorrow. In the meantime, you find out whether these procedures have been followed. If followed, ask them to send you a scan copy, and you can
All right.
produce it tomorrow, because we are only concerned with form 1, 2 and 4, correct? Mr. Counsel,
My lord,
these are the 3 forms we are concerned with, 1, 2 and 4.
Rule 14 also, Your Lordship.
Rule
14,
1, 4.
1-4. It is the duty of the chemical
See,
laboratory
all
to-
this are these are directory. Rule 14 cannot be mandatory. This is the chemical test. It will depend on the facts of each case. But be that as it may, you check up.
I'll check it up. But my lord, we have to see that this is a bail application under section
I
37.
understand, but you see, if the procedures are not being followed, then ultimately the trial might be vitiated, because
Yes.
what is this court, the discretion and what the court has to see under 37 is at the end of the day whether a prima facie conviction is possible or not, correct?
5.
This is what I have to see. Now suppose the mandatory provisions are not followed, then how can a conviction be prima facie? In that event, this court can always grant bail. Are you following what I am trying to say?
Yes, my lord. I
So
know.
two things you need to satisfy. One, whether these provisions are procedural or directory. Are mandatory or directory. There are decisions, because 1 or 2 provisions are mandatory, the apex court has held, but this appears to me procedural. They will not vitiate the trial, non-compliance of these procedures. Okay, so just check that position, and also if the forms are available. So I'll have this reposted tomorrow.
My lord.
My lord, let it come
Now
up on
tomorrow,
Thursday.
don't come up with some additional grounds that this particular form is also not followed. Please give whatever
my lord.
forms you, according to you, are not followed to Ms. Linda, so that she can come back with the accurate information. I take arguments to be completed only on this point. No further argument. I'm making it clear. Only on this point, and if there are any decision, you may also show if
lord.
there are decisions to show that these are mandatory provisions. All right.
Can it be taken up on Thursday, my lord?
All right. Thursday.
Obliged.
Oblige, Your Lordship.
List again on Thursday, huh?
For motion, item number 1.
Yes, Ms. Kanai. Review.
Yes, revision. Yes, my lord, I have seen that there are some technical defects may be allowed to withdraw with liberty to file afresh.
I strongly object, my lord. Because see, they have already filed their review application in the lower court also. If they were given another chance for filing,
No, but you have filed an application, revision. This revision is against the rejection of the review.
yes, my lord.
Show me that the review is maintainable. Otherwise, I'll dismiss it. What is there? Because even if you withdraw the ground, you cannot change the ground, correct, Ms. Vinay? The order stands. That is the order you're aggrieved. Now, that is an order where the review was denied because it has been seen that the grandson has no right, correct? Do I remember the facts correctly?
Yes, my
This
lord.
is that
Yes,
case.
my lord,
Yes,
he have a right. He is the son's son. Okay, and he,
No,
he-
some
They have no locus standi and prima facie
some
to claim the grandfather's
provision of
property.
the Mizo Marriage and Divorce Inheritance Act was quoted. Now you see, you don't have a rehearing. Review is not a rehearing. Correct. You must show that there is an error apparent on the face of the record. Therefore, I was asking you yesterday, where is this error? I don't find an error apparent. Order 47, Rule 1, review. Which is the order provision under the CPC for review. Read it. You have to make a case within the ambit of that provision, right?
yes, my lord. Section review 114, but I have filed this as section 115.
Correct. But section 115 is the application made
Yes.
against an order where review was rejected.
Yes.
So the parameters of review is involved.
Yes, my lord, as part as the previous order, because it was mentioned that this matter cannot be decided in the application, but in the review application, the matter was decided again in application, because the senior civil judge have no jurisdiction to decide the matter in an application, because the order dated 9
Where is the
page,
original review petition? Page? Is it available here
review
on the
petition is page number 30, page number 30 to page number 35.
Yes, what do you have to say?
May I please, Your Lordship? Even though if the review petition was filed, it clearly it can be clearly sees that from the review order. If I may take you to Roman number 2, Ra number 3 and 4.
Yes.
If I may read out.
Yes, please.
On the other hand, learned counsel for the respondent submitted that the heirship certificate number 2230 of 2019 was applied on the basis of settlement between the surviving sons of Van Huitanga, wherein father of the petitioner number 2 was alive and had consented to the application, thus submitted that there is no error apparent on the face of record while issuing the impugn order. Para number 4, the main contention of the petitioners is that they were not given opportunity of being heard, while the respondent had applied for the impugn order and Heirship certificate number 2230 of 2019. However, the respondent is the sole surviving son of Van Huitanga and thus is the only direct legal heir of the deceased. Although opportunity of being heard were to be given to the petitioners as prayed for, they are not entitled to the grandfather's property as per Chapter 8 Inheritance of Fathers, Head of Family Property under the Mizo Marriage, Divorce and Inheritance Property Act 2014. Thus, it is held that there is no discovery of new and important matter of evidence, nor mistake or error apparent on the face of the record, nor any other sufficient reasons to review the order dated 28/11/2019 on Heirship certificate number 2230 of 2019. Hence, the petitioners are not entitled to the review as prayed for. So here it clearly mentioned that whether the notice was not notice was issued through newspaper or not. So there was no other new evidence. It clearly mentioned here in the order also there was no discovery of new and important matter of evidence, nor mistake of error apparent on the face of the record, nor any other sufficient reason to review the order. So, as we are the only surviving son from Van Huitanga, and the petitioner is the grandson of Van Huitanga, of the head of the family, so they have no locus standi and other prima facie to
Sorry.
claim.
No, my lord, as per this Mizo Inheritance Chapter 8, on Section 31(3), it was clearly mentioned
Section
that on 2 and
31(3).
3, it was clearly mentioned that on 2, who are by the sons who are not in Dang, means who have not shifted out from the family property. The respondent has already shifted out from the family.
You see, then it's what is required is a rehearing. You have your remedies open. You could have filed an appeal.
Yes, my lord.
But
And
that is why, you see, yesterday, Ms. Finai, I have heard you in detail. I have asked you the provision of review. You were not aware of the law. That is why I gave you time. Now, you have to understand that you have to make out a case for review. The court has heard the review petition, came to a finding that there is no error apparent on the face of the order, and therefore rejected the review. Against that order, you have come in revision. I am not saying that you don't have any case. You may have a case, but you will have to file an appropriate, you'll have to approach before the appropriate forum. Review cannot be a rehearing. Review is only to show that this is the error which has crept in and that is apparent on the record. And it did not require a detailed arguments, because if detailed argument has to go, that means the error is not apparent, isn't it?
yes, my lord.
And I have read all the grounds that you have mentioned. Those grounds are not grounds of review in the petition. I am sorry, I am not inclined to allow this revision. I'm going to dismiss
no,
it.
my lord.
You may withdraw, but I am not inclined to give you liberty. So choice is yours.
Yes, on point 4 of the order, it was that it was mentioned that there is no discovery of new and important matter. It was there because it in the review petition, the petitioner has annexed the order dated 9/9/2019. There is a new evidence.
Which one?
New
Which
evidence.
one? Which one?
Page number 12. On page number 12, the order dated 9 September 2019 was annexed in the review petition. So this is the new evidence, and and also this is an important matter because this order was not challenged by any by the respondent or by the petitioner, because in this order it was clearly mentioned that this matter cannot be decided in application, and it
This
was
9 September 2019 was already there.
Yes, yes, my lord. We have annexed.
And the order which you are seeking review is the order of 28/11/19. Correct?
Yes, my lord. This cannot come into picture anymore.
Huh?
This cannot come into picture anymore. This order of 9 September 2019. Because it was already dismissed, and right now the order.
All right, I have heard you all enough. Now, please take your seats. Heard MSL Fanai,
Yes.
Learned Counsel for the petitioner. Stop. Also heard Mr.
Zodin Pinamte.
Zodin Puya Hamte,
Yes, my lord.
Learned Counsel for the respondent. Stop. This is an application under section 115 of the CPC, read with section 151 CPC, against the order dated 29/11/2023, passed by the Learned Senior Judge 3, Aizawl District, Aizawl, in review application number 35 of 2022, A stroke arising out of Heirship certificate number 2230 of 2019. The brief facts of the case is that Vannaithanga, who is the grandfather of the petitioner and the father of the respondent, had left a landed property covered under LSE number AZL333 of 1974, located at Nursery Weng, Aizawl, Mizoram. The respondent had previously applied for issuance of heirship certificate in respect of the said land in the year 2017, which was registered as heirship certificate number 740 of 2017, and the petitioner submitted an objection. Hence, the heirship certificate number 740 of 2017 was dismissed by an order dated 9/9/2019. Stop. It is the further case of the petitioner that, however, the respondent filed another heirship certificate in respect of LSE number AZL333 of 1974 without issuing notice to the petitioner. Stop. It appears that the Senior Civil Judge 3, Aizawl District, Aizawl, passed an order dated 28/11/2019 and issued heirship certificate number 2230 of 2019 to the respondent by memo number 330 SCJA3/2019 dated Aizawl the 28th November 2019. Being aggrieved by the aforesaid order, the present revision petition has been filed. Stop. Ms. L. Fanai, Learned Counsel for the petitioner, submits that the order dated 28/11/2019 is required to be interfered in as much as, despite there being grounds for review, the order dated
9/9/2019.
the order dated 28/11/2019 was not reviewed by the Learned Civil Judge, Senior Division 3, Aizawl District. Stop. She further submits that since the impugned heirship certificate was granted without issuing notice to the petitioner, the order granting heirship certificate is required to be reviewed. Stop. Correct?
Yes, my lord.
Per contra, Mr. So-and-so, Learned Counsel for the respondent, submits that there are no error apparent on the face of the record, and therefore there is no ground for review, and as such the trial court has correctly rejected the review application. Stop. That's your submission.
Yes.
Before going to the submissions made by the learned counsels for both parties, relevant portion of the order dated 29/11/2023, which is assailed before this revisional court, is extracted hereunder for ready reference. Paragraph 3 and 4. It appears that the trial court has rejected the review application on the ground that no error apparent on the face of record has been shown by the petitioner. Stop. It further appears that the trial court has taken note that the petitioner are not entitled to their grandfather's property in terms of Chapter 8 of the Meso Marriage, Divorce and Inheritance of Property Act 2014. Stop. Pertinent to refer to the provision of don't say. Pertinent to refer to the application filed by the petitioner before the trial court for review of the order dated 28/11/2019. Stop. Paragraphs The grounds for review as stated in paragraph 10 are extracted hereunder for ready reference. A to A, page 33. It is well settled law Councillors, please take your seat. It is well settled law that a party is not entitled to seek a review of a judgment delivered by the court merely for the purpose of a rehearing and a fresh decision of the case. The court reopens its judgment only if a manifest wrong has been done and it is necessary to pass an order to do full and effective justice. In a civil proceeding, an application for review is entertained only on a ground mentioned in Order 47, Rule 1 of the CPC. Order 47, Rule 1 of CPC is extracted hereunder for ready reference. Thus, the power of review can be exercised only for correction of a mistake, but not to substitute a view. Reference is made in this regard to the decision of the Apex Court in the case of Lily Thomas versus Union of India, reported in 2000, volume 6, SSC 224. Perusal of the impugned order dated 29/11/2023 appears that the trial court, having not found any error apparent on the face of the record, rejected the prayer for review. The said approach of the trial court appears to be in conformity with the powers of review. In terms of Order 47, Rule 1, and also as per the catena of decisions laid by the apex court. Stop. Thus, this court finds no infirmity or illegality in the order dated 29/11/2023 passed by the Civil Judge Senior Division 3 Aizawl District, Aizawl. Stop. Accordingly, the revision petition stands dismissed. No cost. Sorry.
Much quicker.
For admission, item number 2.
Yes.
My lord, in the last court, 3 court dated 22nd August 2024 and 27.
Yes, where are the respondents?
My lord, I am
Yes,
appearing
Miss
for this
Mary?
one. Yes.
Have you complied with the, you are supposed to bring on record some instructions, correct?
Yes, my lord, I would like to express my gratitude for this honorable court for entertaining my learned friend while I was in absence in the last court date. There was a mistake of fact, but then, however, that instruction was sought for, but then I can give the instructions to the effect that there are 2 clauses as per the memorandum of settlement that we have to comply. So, as per the memorandum, the clause number 2, then the sub-districts
Miss Mary, where are the
all
instructions?
Yes, departments, my
Miss
lord.
Mary, where are the, have you placed the instruction in the court?
No, my lord, I will just give it orally, my lord. There
No,
is
but,
no
you see-
specific numbers.
No, Miss Mary, the order of this court dated 28/8/2024 is very clear. It says, list this matter again on so and so, on which date the instruction as sought for by this court shall invariably be placed before this court, failing which this court would pass orders requiring the personal appearance of the concerned respondent before the court. So if you
My
have
lord,
got the instructions, please place
My
it
lord,
before
it
the
is
court.
already on affidavit. It is already on affidavit. So that is why I was on absence and they did not know. So that is why I am trying to explain. We have already filed the affidavit, placing all the materials.
All right, I will record your submission and we'll have it on another date. The affidavit is here.
Yes, my lord.
Which is the affidavit?
Yes, if we are to do the hearing also, I am ready, my lord.
Sorry,
I am ready for hearing also, my lord.
which is the order, Mr. Counsel? Which is the order that has been not complied according to you? Where is the order?
My lord, contemplation page number 9.
Page number?
9, my lord. Clause number 1 also not yet complied, my lord.
Page
Not in-
number 9. Yes.
My lord, page number 9, clause number 5.1. If I permit, my lord, I will read. With a view to satisfying the desire and aspirations of the Mar community in Mizoram, the state government will initiate measure for use of Mar language as a medium of instruction up to primary level. This is not yet complied, my lord. Only recognition of Mar language is complied in clause number 5.1 because we have applied for RTI.
One second, let me understand. With a view to satisfying the desires and aspiration of Hamar community in Mizoram, the state government will initiate measures for use of so-and-so as a medium of instruction up to primary level and recognition of Tamil language is one of. Is this done?
Recognition of Mar language is done. But the first
Recognition.
part is not done. my lord.
Recognition is done. Which part is not done?
5.1 first part and 5.3.
No,
5.3 total.
measures have not been taken to use this language as a medium of instruction.
Yes, my lord.
That is not done.
Not done, my lord. And we,
My lord, this is just.
One second, Miss Mary.
Sorry.
This is not done.
5.1 first part not done, my lord.
But they have recognized the language as a major language for the state of Mizoram.
Yes,
that
madam.
has been done.
Yes,
So
madam.
now this needs to be executed at the ground level, at the school levels.
Yes, my lord.
Correct?
Yes, my lord.
Okay. And what
And
about
my lord, we have applied RTI, the copy also.
what about 5.3?
5.3 is no, my lord.
A
Different
new
as the-
subdivision, a civil subdivision will be opened, and the subdivisional officers of different departments will be established at convenient location in the area. The primary health center at so and so will be upgraded. These have been done.
My lord, it is as per 5.3. Different as subdivisional offices will be established.
Is it done or not done?
Only 4 subdivisional offices established till now.
Only 4. How
Only
many?
4,
How
my
many requires to be there?
As per their reply from the affidavit, there are
How many more?
19 department. My lord.
90.
19 department is
19.
19, my lord. But only 4 of them.
So
Subdivision
19.
offices.
According to you, 19 subdivision is required.
Yes, my lord.
Okay. What is that RTI you want to show?
My lord, from RTI, we have applied to educational department. Mention the name and address of the school who practice Mar language as a medium of instruction up to primary level at Freelong Hill Council area. And the reply is,
Yes.
the medium of instruction at government primary level in Mizoram are Mizo and English. However, NCRP
So Hamar language is not there.
not there, my lord.
However, the SCRT developed and published Hamar textbooks, which is to be extended to higher classes in phased manner for use. Unfortunately, there seems to be no buyer. But that is not the order of the court. The order of the court is that the government has to initiate measures for using Hamar language as a medium.
Yes, my lord.
So that has not been done.
Yes, my lord. And this contempt petition, my lord,
All right, one by one. Miss Mary, all right, you clarify one by one. Otherwise, it's confusing. Now, as far as 5.1, the first thing is that the state government will initiate measures for use of Hamar language as a medium of instructions. Has that been done? Because the petitioner has made an RTI inquiry against that. It appears the director SPIO SCRT has given a reply which says that the medium of instruction at government primary schools in Mizoram are Mizo and English. So it appears that the first part of 5.1 is still not done. You may show me if there is something else in your reply. But this is 30th August 2023, which says it is not done.
My lord, with response to para number 5.1, the government have made a notification dated 8 January 2024, which is in my affidavit.
Where?
Proposed-
Page?
Proposed reply affidavit of respondent.
Yes,
number
I have
3,
it.
Page number 1.
Page number 1.
Yes. Sorry. Page number 6, annexure number 1.
This is an affidavit in opposition on behalf of state filed on 9/9/2019. Here,
My lord, that is an old one.
which
No,
one?
the-
Which one are you?
Documents I am referring.
There are
is
so many
I-
affidavits
Yes, so many affidavits.
Which one?
Just have-
filed on 15/11.
show cause reply affidavit of respondent number 3 and 5.
3 and 5.
Consolidated affidavit. It's a small affidavit, 2-3 pages only. It was filed on 15/3/2024.
Yes, I have it. Now you want me to go to page number
Page number 1. Sorry, page number 6.
6.
Annexion number 1.
Yes. This is a
So,
notification of
here-
8 January.
Yes.
The government, so and so, the governor is pleased to recognize so and so as a major. Yes, that is all right. This is the second part. You see,
Yeah.
in that direction, the second part was for recognition. That you have done. In fact, the petitioner says that you have done. But what about the medium of instructions at the government primary schools? It has to be
My lord.
executed. That
My
has not
lord.
been done.
My lord, unless notification is required, there is no notification required for making Mizo as language because it's a major language recognized by the state, so that is used as a medium of instruction.
Miss
So
Mary.
now it's recognized.
Miss Mary, it has been recognized, I understand, but you have to read 5.1. Kindly see. With a view to satisfying the desires and aspiration of Hamar community in Mizoram, the state government will initiate measures for use of Hamar language as a medium of instruction up to primary level. This is number 1. And
Yes.
recognition of the Hamar language as one of the major language of the state of Mizoram. Second part is fulfilled by this notification of yours, 8/1/2024.
As medium of instruction, no notification is yet made, my
So
lord.
that means the order of the court is not complied. Because paragraph 7, in view of the submission made by the government advocate, this court directs the state respondents to comply with 5.1/5.3. The state will act upon the above two clauses at the earliest and preferably within a period of 1 year from the date of receipt of a certified copy of this order. So it appears the first part is not done. The order of the court is not
My lord,
complied.
I will just, if I may be given time, I will just take instructions from the
No,
concerned
Miss
department.
Mary, I'm sorry, but it appears that there is some lack of communications because the order of the court was very, very clear that if today
Yes, my lord, there is some gap because I was
No,
on
no,
leave.
I'm sorry, it doesn't look good. So I will give you the chance, but you please come up with this because
Yes.
if
Yep.
this medium thing is not done, then there is a clear violation of the court's order. And this
I will
cannot be
information.
tolerated. It appears the order is very clear, unambiguous order. How can the order not be complied?
My lord, I don't know whether it's notification is there or not, but I
No,
will
I
just get
this document which has been placed before this court makes it clear that till 30th August 2023 there was no medium of instruction. However,
Now we-
your recognition appears to have come on 8th January 24. So maybe
Yes.
something has come by now.
yes,
So
my
you
lord.
verify that.
Yes, my lord.
All right,
If I may be given time, my lord. Yes.
Mr.
Nichuga long, my lord.
Mr. So and so, learned petitioner places an RTI reply received on 30th August 2023 from the Office of the Director and SPIO SCRT Social Education Department, Government of Mizoram, whereby it was informed that the medium of instruction at government primary schools in Mizoram are Mizo and English. It appears that clause 5.1 of the memorandum of settlement, which was directed by this court by order dated 4/9/2017 to be complied by the state respondents, has not been complied till date. Ms. Mary so and so draws the attention of the court to the show cause reply filed on behalf of the respondent number 3 and 5 on 15/3/2024, wherein a notification dated 8 January 2024 is enclosed, which shows that the government has recognized Hamar language as a major language of the state of Mizoram. In pursuance to para 5.1 of the said memorandum of settlement. However, there is nothing on record to show that Hamar language has been used in the government primary schools as a medium of instruction. Ms. Mary seeks 1 week time to clarify the above.
My lord, may I be granted at least 2 weeks' time?
2 weeks time to clarify as whether the state government has initiated measures for using Hamar language as a medium of instruction at the government primary schools in Mizoram. Stop. It is needless to be clarified that prayer is allowed. It is needless to be clarified that in the event the aforesaid clarification is not placed before this court by way of an affidavit on the next date of listing, the erring officers, who are the erring officer, Miss Mary? Who is responsible? I will ask him to be virtually present in case the affidavit is not filed.
My lord, it's in this case it will be the secretary school education department.
Respondent
but
number?
I don't know whether he's inflated.
Respondent number 3 and 5.
Respondent.
Chief Secretary and
Okay.
Oh, my lord, that is chief secretary and home department.
One
Just
sec.
the school department, education department.
Respondent number.
He's not. They are not inflated. School education department.
Respondent number 4 is Secretary to the Government of Mizoram Home Department, Aizawl.
Yes.
Respondent number 5 is the Secretary to the Government of Mizoram Home Department.
Home department only.
So who has to be present?
My lord, it is the school. It's the purview of the school education department. So they are not inflated in the case.
So who has to comply this direction?
It's the school education
no, my
department.
lord, it is the Chief Secretary and the Home Secretary. They are the head of the department.
They are
listed.
the respondent numbers
3 and 5. 3 is Chief Secretary
and 5
and
is.
5 is Home Secretary, my lord.
As of now, I am only asking R5. Respondent number 5 shall be virtually present. Shall be present in the court through virtual mode.
Yes, ma'am.
You file it, then not required. But if that affidavit doesn't come on the next date, then he has to be virtually present. List
in
on,
that
yes,
case-
date. Give me a date.
Yes, my lord. Next month.
Date.
Month. 10th of next month.
10/10/2024. Next matter,
Yes,
please.
Right, ma'am.
10 is a Miss Mary, 10th I'm told is a holiday.
Sorry, my lord. I did not.
Yes.
11.
Is
11
11 a working day or not? Miss Sangpui? Is
Oh, it's
11
not
a working day?
That whole week is not a working day.
Whole week is holiday.
Oh,
here.
then why are you giving me these dates? Give a date when the court is open.
I don't have the court calendar. Sorry,
Yes.
my lord.
14.
14, my
14?
lord.
14?
Yes, my lord.
Okay. Is 14 working day or not?
Working day, Madam.
Working-
All right.
Sunday.
14,
Sorry,
10.
my lord.
All right, all right. When are you joining back, Miss Mary?
Hopefully from next month. That is why I keep saying next month, next month.
Okay, okay. All right. 14, 10.
I'm deeply obliged.
Item number 3.
Service is completed.
Yeah, Your Lordship, ID card is not yet returned. Await service report,
Await service report for respondent number.
15.
Okay. Record their presence and say await service await service report in respect of respondent number
15.
List after 2 weeks.
1 week. Your Lordship.
List after 1 week on a date to be fixed by the registry.
Item number 4.
In this case, Your Lordship,
Counter. Affidavits filed.
yeah, before, the fact is that after passing the order by the single bench, they have filed appeal before the division bench, which was dismissed. After dismissal of their appeal, they have not yet taken step to comply with. So far as my knowledge, there is no appeal against the.
No, but who is appearing for the
Yeah,
respondents?
they have. In fact,
My
Your
lord, I
Lordship,
have
Miss Mary, I think you
yeah,
are there.
Mary is appearing in.
Have you filed your counter?
My lord, we have filed a counter in as much as that the what my learned friend have submitted, that appeal was filed and then appeal dismissed, and then now
They just inform the appeal is filed. That is
Yes.
their affidavit. After the
No, but
appeal
what
is
happened to that appeal?
dismissed.
Then it has to be
dismissed, and now-
complied.
Yeah, it has to be complied. We
Miss
have-
Mary, I'm posting this also in the month of October. By then,
Yes,
you verify what is happening. If required, you make your stand clear. Otherwise, if the appeal is dismissed, then how can the order of the court not complied?
my lord, they're taking positive steps, but then the step is not taking very fast. That's it.
Sorry.
They are taking positive steps, but then
So
I
what
do
is
not
the
know-
step taken by them? They have to
Yes, I
inform
do
this
not know
on
the step.
board.
MS
Dinari.
Denari T. Azul Learned Counsel for the petitioner submits that the respondent has taken the ground that an appeal has taken the ground that because of an appeal being pending before
Before division bench.
the division bench of the of this court, comma, the order of the court was not acted upon.
Yes.
Stop. However, MS Aju Learned informs that the said appeal has been dismissed
On 22,
on
9,
22
2023.
2023. Stop. MS Mary seeks 2 weeks time to obtain instruction in this regard and inform the court as regards the steps taken by the respondents to comply with the court's order passed earlier, against which the contempt petition has been filed. Prayer is allowed. List this matter after 3 weeks.
2 weeks.
After 2 weeks on a date to be fixed by the registry. You please inform what are the steps taken and what has happened to the appeal after the appeal being dismissed. All right? I can't hear you, Miss Mary.
My lord, if I may be given 3 weeks, my lord.
All right, 3
Your
weeks.
Lordship, the appeal is dismissed on
Yes, but Miss
2023.
Aju, you see, Miss Mary is also on leave, maternity leave, right? She's
Your
joining, I
Lordship,
think, next
They
month.
have taken so much time
it's,
after
All
dismissal
right,
of the appeal.
I'll add
Fine,
this.
fine.
It is needless to clarify that the affidavit and or instruction as sought for is not filed by the next date of listing, comma. Yes, which officer? I'll ensure that officer is present in the court. Who has to be present in court?
Yeah, I'll come to that.
Tell me. Respondent number so and so shall be present in the court through virtual mode. Tell me the respondent number.
Secretary DRDA.
Respondent number?
Respondents number. Respondent number 3, but I don't know whether he is still the same person or not, my lord.
No, that's all
Because
right. Let
He is changing every now and then.
respondent number.
At that point of time, it was number 3.
So
that is-
many show cause notices. Where is this petition contempt? Contempt petition. Yes, respondent number.
Your Lordship, I misplaced my contempt petition. I'm just searching for the.
Number 1 is just secretary. Number 2 is secretary rural
Even I
development.
can't find my contempt petition.
I
Yes,
have a
respondent 3 is the secretary to the Government of Mizoram Department of Personal and Administrative Reforms. He is the concerned person. Or the principal secretary. Secretary or number 5, secretary to Government of Mizoram Planning Department.
no planning.
Planning only.
5?
5 is,
Is it 5, Miss Mary?
Oh, my lord, this case concerns with the employees of DRDA. So I believe that Secretary DRDA should be the
no,
concerned
no,
authority.
planning it's covered because the
Then
DRDA is
DRT
the
is
scheme.
number
under
6,
the-
the Director, Rural Development Department, Government of Mizoram. I'll ask R6 then,
Yes,
right?
yes, that will do.
R6 within bracket you write
5 and 6.
Shri R Lalthaswala, the Director, comma Rural Development Department, Government of Mizoram, Aizawl.
Yes.
Okay?
Yes, my lord.
Yes. Next matter.
Item number 5.
As allowed by this honorable court, we have served notice by way of justice
Yes.
and we have filed the affidavit.
Mr. Miller, you're appearing for
I'll be appearing for respondents 1 and 2.
1 and 2. Who all are there?
Only 1 and 2, my lord.
Oh, so
PC
Mr.
and-
Miller is appearing. So service complete?
Yes, my lord.
Correct. This is what? This is the first appeal.
This first
Yes,
appeal.
my lord.
It's not admit. I'll admit it.
Yes.
My
It's a
lord,
statutory appeal, Mr. Miller.
Yes, my lord. I'll be also filing my affidavit.
You
my
file.
bagalan, ma. Sorry.
You file whatever
Yeah.
you want to file. It's a statutory appeal.
Yes, my lord.
Why is it not admitted till now?
This is my first appearance, my lord, in this matter.
No, Mr. Miller, first, these are statutory appeals. In
Yes, my
fact, generally, we, in the principal seat, we admit and we issue notice.
Understood.
Because you cannot object to the
Yes, yes.
admission. It's a
Yes, madam.
statutory appeal.
That's understood, my lord.
Yes. Heard Mr.
Zoram Sana.
Zoram Sana, Learned Counsel for the appellant. Also heard Mr. Miller, Learned Counsel for respondent number
1 and 2.
1 and 2. This,
I'll be filing my bagalan in the
yes,
next
yes,
2 days.
I will record that. Don't
Yes.
worry. This appeal is preferred under section 96 CPC, read with order 41, rule 1 CPC, read with section 17 2B of the Mizoram Civil Codes Act 2005 against the impugned judgment and order dated 23/3/2023 passed by the Court of Senior Civil Judge 3 in eviction suit number 6 of 2017. Admit, issue notice, returnable, 2 weeks. Stop. Mr. Miller enters appearance and accepts notice in respect of respondent number 1 and 2. Stop. As such, no formal notice. Extra copies to be submitted within a period of 3 days from today. Call for the records from the Court of Senior Civil Judge 3. List after paper book also has to be prepared, right? Let registry prepare. Not required.
Because it's a very simple issue.
All right. List after returnable. I said how much? 3 or 4. After admit, issue notice. I said no returnable. 2 weeks. No, make it 3. List after 3 weeks on a date to be fixed by the registry. And in the beginning, where I said also Mr. Miller, there you say Mr. Miller has entered appearance, has submitted that he has instructions, he has received instructions to appear on behalf of respondent numbers 1 and 2, and accordingly submits that the requisite wakalatnama shall be filed
2 days.
within
Within
a
2 days.
period of 2 days,
2 days.
from today.
Obliged, my lord.
Obliged.
Item number 7.
As per the last court order, my lord, the respondent is to place on record the order disposing of the representation filed by the petitioners.
Yes, Ms. Fanai was given time. Yes, where is that order?
Yes, my lord, we had replied the representation, we had given the annexure. However, as per the order, the last court's order, we had given the copy, a reply of the representation in writing to the petitioner.
That's right. You have received a copy?
My lord, she has sent me a soft copy just now, so I have
My lord,
not gone
we've
through
given
yet.
it to the petitioner.
Have a look.
Yes.
Have a look. I'll resume in 5 minutes. You have a look. If it is, if the order is complied, then no point of keeping this contempt
Yes,
petition
yes.
pending. I can dispose it of. Yes, complied or not complied?
My lord, I have gone through the said letter, and it appears that the NHIDCL is refusing to comply with the award passed by the collector. So the problem,
The order of this court is complied.
yes, my lord, it's complied in a way.
No, if it is complied, then you, even if you are not satisfied, that is a different thing.
Yes, my lord.
I'll close the contempt then.
Yes. But very strange though, my lord. Because as per the Act, as per the National Highways Act, the competent authority is the authority to prepare the what?
Is
He is the competent authority for land acquisition.
Kala is there.
Yes, Kala is there. Kala has made the award. We are to receive the money in terms of the award. However, it appears NHIDCL, the company is refusing to.
Which is the order against which this contempt is filed?
My lord, page 16, my lord. Page 17 being the operative portion, my lord. Oh, last para, page 16, last paragraph.
Yes.
Having heard the submissions made by the learned counsel for the petitioners, this court, in view of the limited prayer made by the petitioners, find it fit to dispose of the extended petition with the direction that the petitioner should approach the respondent number 2 by way of a
So
representation.
the only direction was that the respondent number 2 should
Yes.
consider and dispose of the
Yes, yes.
representation once filed,
Yes, yes.
along with the pending representation for assessment of the value of the land acquired by the respondents with a speaking order, and as per law within so and so. So the order was for disposing of the representation.
Yes, my lord.
Now this is the order by which the representation has been disposed of.
Yes,
Correct.
Yes, my lord.
Then it has been done. Nothing survives.
So we'll have to file a fresh suit, my lord, a fresh case against the NHIDCL. Because award has not been challenged, and the award has attained finality, but nevertheless the paying authority.
Yes, because now
sanctions
you see,
the
it is not for this court to
Yes,
get
yes,
into all this.
Yes.
Why the front page is not there? Oh, this is.
My
This
lord,
starts
that's
like
the
this.
representation.
Heard Mr.
Zoram Sana.
So and so, learned counsel for the petitioner. Stopped. Also heard MS.
Then I Sakifanai,
So and so, learned counsel for the
sole respondent.
sole respondent. Stop. By filing this application under Article 215 of the Constitution of India, read with Section 12 of the Contempt of Courts Act 1971, the petitioner draws the attention of this court the willful non-compliance, the alleged willful non-compliance of the respondents in complying with the directions made by this court in order by order dated 1/12/2023, passed in WPC number 147 of 2023. Today, when the matter was called, MS so-and-so, learned counsel for the respondent, submitted that the representation of the petitioner has been disposed of in terms of the court's order dated 1/12/2023, passed in WPC 147 of 2023, against which the aforesaid contempt petition has been filed. She further submits a copy of the order dated 9 September 2024, issued by the Additional Deputy Commissioner and Competent Authority for Land Acquisition, Saitwal District, Saitwal, whereby the representation of the petitioner dated 6/2/2024 is disposed of. The effort, you give another copy, huh?
Yes, my lord.
Along with a copy to the other side. The said order dated 9 September 2024 is kept on record and marked as X. Perusal of the aforesaid order dated 9/9/2024, indicates that the respondent has considered and disposed of the representation of the petitioner as directed by this court by order dated 1/12/2023. As such, nothing survives for adjudication in the present contempt petition. Accordingly, the contempt petition stands closed. Before that, you say that just before the perusal, you say Mr. So-and-so, learned counsel for the contempt petitioner, submits that the case of the petitioner has not been considered. It has not been considered, right? Represent the representation?
Representation is considered, but my lord, it in a strange way, my lord. If you go to the letter, that order.
All right, this is not required. No need to say all this. It is needless to clarify that in the event. All right, not required.
It is given in the first order.
It is given in the first order.
Yes, yes.
So,
But to file afresh.
yes. See, this has stayed here. This was supposed to be marked RT application in that other contempt petition. Yes.
Obliged.
Disposed of.
Part 2, item number 1.
My lord, the
This
opposing
is-
counsel is not present today. But
Is it?
nonetheless, my lord, this is that RSA,
Yes. Heirship certificate.
airship certificate.
Nature.
Nature of the airship certificate. So, my lord, I have done some research. And this is what I have found, my lord. And I think this judgment sort of encapsulates what I can understand. I'll provide this judgment.
Nitya.
Now, my lord, in this case also, if your lordship will, I'll just take your lordship to the first 3 paragraphs just to understand how this case, my lord. First 2 paragraphs. The appellant's counsel submits that the land covered by LSC number 562 of 1977 was originally owned by one Mrs. Lalswangi. Mrs. Van Lalswangi has 3 daughters and 2 sons who are as follows. These are the sons and daughters, and the 5th one is the appellant. Now, 3rd paragraph. The appellant's counsel submits that Mrs. Van Lalswangi died on 18/7/1982. Thereafter, an application was made by Lalring Ngeti for issuance of heirship certificate in favor of the appellant in the court of the subordinate district council court, Aizawl, in respect of LSC number so and so. The magistrate first class subordinate district council court issued heirship. So this case also, my lord, came up from heirship certificate case. It went all the way into an RSA, my lord, just like the present case. Now, in this case, what the court finally decided, my lord, before I take your lordship to the reasoning, if your lordship will come to paragraph number 23.
Paragraph number 20.
3, my lord. Now, what the court decided, my lord, was this. In view of the reasons stated above, I uphold HC number 54 of 1994 and direct that all the properties covered by LSC number so and so shall be the property of the appellant. So the title of the appellants with respect to this property is decided in this case, my lord. no right of title or interest can devolve upon the respondent or lal nun tluwangi. So, my lord, what I can understand is at least the title of these people were decided. In a will, my lord will remember, in a probate case, title is not decided. It's only the genuineness of the will.
You couldn't find any other decision.
My lord, there are very less reported judgments. And if your lordship will come to paragraph 20, this is one of the reasonings that has been,
20?
paragraph 20, my lord.
Yes.
The next question that has to be decided is whether the property covered by LSC number so and so could have been distributed to the respondent and lal nun tluwangi in view of the fact that the Mizo customary law requires inheritance to devolve only through the male lineage. Then it cites as Guwahati High Court judgments, paragraph 15 of that particular judgments, which says like this: the law of inheritance thus explicitly excludes women if the deceased is survived by son. The present case, there is no dispute that Thanhuna was the only surviving son when his father, P.S. Daroka, died on 5/3/1978. The inheritance or title, my lord, this is something that because inheritance or title means it's used synonymously. Inheritance or title to the properties of a person does not stand or hang on his death. It starts to flow automatically with the death and rest on the person who is the legal heir in accordance with the law applicable.
So this appears that here the ownership is concerned.
Yes,
It is not a mere succession.
correct. So it has dual roles. Once you decide the
So
ownership,
if the ownership is concerned, then of course one has to see
yes,
whether the original,
that's my understanding, my lord.
yes,
And my lord, in this it says it does not depend on issue. This is something that I'll try to explain, my lord.
but come towards the end of that paragraph.
Correct. This is what I want to explain to my lord, my lord.
It
On
does-
issuance of any heirship certificate,
It does-
such a certificate is issued only to formally recognize, modify, and update the records of rights.
This again is
This
against
creates
you.
a dilemma. But
It is against you, this part.
no, this is exactly, my lord. This is because it goes counter to my. But what I
I
understand.
think since he is also not there today,
Yes.
we can have it tomorrow or Thursday.
Tomorrow is the DB, my lord. Thursday, I think
Thursday?
Thursday will be better.
We can have it on Thursday, but you see, I'm only here this week.
Exactly, my lord.
Since the parted matter, we shall try and at least finish the hearing on Thursday. Only on this part.
Only on this
because
part.
even if you go by this decision,
It becomes difficult.
it is again saying it is only a formal recognition.
recognition.
Now, if it is a formal recognition, then it is be akin to the succession.
Let me try to explain, my lord. I will explain on Thursday also, my lord. But just
I think, Mr. Joseph, you will need to get hold of the relevant rules from the beginning. Maybe because I remember in one case, I have seen there are some rules for registration and all that also, apart from your Mizo inheritance. And before that, there was something else, isn't it?
the Mizoram Inheritance of Property Act 1956.
I think which one is applicable in your case?
Now, in my case, my lord, it has to be the customary law.
So where are those?
The customary law, my lord, I will try to provide. There is a book which lists some
You
customary
get
laws.
hold of all that.
All this.
You see there.
Yes.
Because you see more, it has now also become an academic
Exercise.
issue, right?
Correct.
And if there is some clarity, it will always help you all,
Yes.
isn't it?
Yes.
Now it appears that maybe this issue never cropped up.
Yes.
The nature of the heirship proceedings.
Yes.
So,
So, my lord, yes, your lordship, I'll look into this. I completely understand. I'll look at the video also again, my lord. I'll see what your lordship wants. But with this point, my lord, let me try to explain how I understand this particular paragraph. Firstly, my lord, when you issue an heirship certificate without going into a suit,
one second. Joseph, LC, can you get hold of this case?
P.S. Daroka.
You have it?
Yes, my lord.
Please give a copy.
Yes.
Let us see it from there. What is this Mizo customary law on inheritance?
This was before this Mizo law was before the 2014 Act. The We used to have we used
Before the 14, now it is 14. Before
Correct.
that, it was Mizo Inheritance of Property Act 19. I think I was referring to this act.
My lord, one thing I want to mention, my lord, this particular judgment was cited in this other judgment, my lord. The reasoning is cited, but that this is the ratio, my lord. The ratio was cited, but this particular judgment, my lord, this is what I was trying to explain that time also, has been overruled in the Supreme Court
By which decision?
by this decision. So we don't have the extra copy of it. This was my copy.
I have seen this decision.
Yes. So in this,
This is kite for me.
yes, this was the appeal against this judgment.
Here they have mentioned to another decision. Get hold of this also, huh? This is Justice Gavai's judgment. Just give me a printout. This one. See, I think you were referring to the Mizo District Council Inheritance of Property Act 1956.
1956.
Maybe then we have that here.
But that is only with respect to wills, my lord.
Let's just have a look once. Not there. Is there in the library? You have a copy of that? No.
We have one, my lord.
You have?
We don't have a hard copy. We have only a soft copy, my lord. The name is.
Just send him. Did you get it? Call them. Call to the library and ask them to send it. No, why I wanted to see this is that maybe we get some, because we've narrowed down the whole thing to one, right?
Yes.
If it is deciding ownership, then of course it needs a remand.
Yes.
But if it is not deciding the ownership, then perhaps.
I think, my lord, this is what I understand. Heirship case have two compartments, my lord. The first thing is it has that element of the ownership issue, because in this case RSA, my lord, this was Justice Michael's judgment. He has clearly given a relief of ownership.
There is no discussion.
Yes, there is no discussion as such. That part, your lordship. But
There
this
is
is
no
this.
discussion.
There's no discussion. But
And the coordinate bench,
yes,
and there is no discussion.
there's no discussion.
And this Justice Pal's judgment, there it appears some discussion, but then that is overruled.
Overruled.
And that discussion also is twofold.
Correct.
One in your support,
The other one
and
is
the other part is against you.
him, yes,
Because then it says heirship certificate is just
Yes.
a
yes.
formal recognition.
Correct.
That means it is not deciding the ownership. Yes or
That's
no?
not. Yes, you're right, lordship.
So the things are not clear, Mr. Joseph.
Yes.
And this way or that way, if we give some finding, at the end of the day, you people will only be affected. It has to be properly given, because there appears no clear decision on this point.
Absolutely agreed, my lord.
So that is why I have been asking you to do a little more academic research, because you might have to find out what are the customary laws. One we have now found is the Inheritance of Property Act.
Correct.
This is one. That apart, there can be another one. During December, when I was holding court here, I remember I had seen some.
No, there is one. I'll bring it tomorrow, my lord. I
Yes,
have one.
there was a compilation. There were one or two more. Somewhere I may have seen also heirship certificate, because in that form they refer to something, but that is from the marriage. inheritance, which was not in existence when this case.
Correct.
Correct. So your case will go to that time prior to the 2014
Yes,
Act.
yes.
And the right, remand has to be not done in a routine manner.
Correct, correct. Absolutely agreed, my
Isn't
lord.
it?
And I, my lord, don't want to misguide the court at all.
No, I'm not saying that.
I would not try to pull your lordship to that because
This court has a lot of faith in the bar.
Yes, yes. And this case has a big significance. I can see it.
That is what I'm saying. It
Yes.
will have a, either way.
Yes.
So for that, I think the relevant law is one which needs to be seen. So apart from this, I think there is one Justice Gogoi's decision also.
That was on limitation.
Oh, that is on limitation.
Whether limitation is applicable in Mizoram. And he says it is applicable in Mizoram.
As far the heirship is concerned, these are the two
There are several, but they have no discussion on this point. By the way.
on this point.
So this one, because the relief given was ownership, so I thought maybe it will have some significance. But the problem
No,
is
you're right. Here, if we go by that other decision,
yes,
the decision in Lalzar Liana,
yes,
there it appears ownership has been
given.
decided.
Yes,
Correct.
but then in
But-
that case, it cites this other judgment.
Correct, which has been overruled.
Correct.
Which has been overruled. And plus, it doesn't decide the question of
It doesn't
ownership.
discuss.
You see, when will it be a precedent? When the question arises, there is argument and there is a decision.
Yes.
Correct. There is nothing. It appears sub silentio to me.
Yes.
Isn't it?
Agreed, my lord.
Because in para 23, it says, in view of the reasons stated above, I uphold so and so and direct that all the property shall be the property of the appellant. No right of title or interest can devolve upon the respondent or so and so. So the right has been decided.
Decided.
But whether that can be done, not done,
Was not discussed at all.
that was not decided. The nature of the heirship certificate, that is not decided.
Yes.
It can be inferred. You're right.
Yes.
One can infer.
Yes.
Only one copy.
It's okay, my lord. I have one.
You have a soft.
Yes.
This you are right. This is only to wills and probate.
Yes.
Nothing of heirship. But you see, there is one more. I remembered customary law. There was a chapter of inheritance, and after that chapter, there was also a how that is done. That there will be an application. They will record. Everything was laid down. I don't remember the name of that.
I will try to find.
Most likely it was some customary book. What are those, Elsie? Those compilations there? What are those compilations? Anything? Just bring it. Bring, and also the blue ones. Just bring it once. Mizo forest. This is not needed. Collection of land revenue. Yes, I think I was talking about this chapter. There is a Mizo District Land and Revenue Act, and here it says settlement holder
Acha.
means any person other than a pass holder who has entered into an agreement with the administrator to pay land revenue and is deemed to have acquired status of settlement holder under section 7. Okay. Now, Section 7. The settlement holder shall have a heritable and transferable right of use on or of subletting in his land subject to the payment of so and so, so and so. So it is a heritable right.
Correct.
So I understand that under this the LSCs are given.
Correct.
Correct. And this shows it is a heritable and transferable right.
Correct. Correct.
Then recording. A settlement holder shall, on the completion of survey and demarcation of boundary, obtain a certificate of recording for the details of that land on payment of such amount so and so, so and so. So that is the certificate. Possession of such certificate showing details of boundary area and assessed revenue to be paid annually shall be deemed to be the conclusive proof that the land has been settled with the holder of the certificate and that all rights and interests arising out of such settlement have vested in such holder of the certificate.
Yes.
So this is how the recording, how it has come. And this right, they are saying, is heritable.
Correct.
So once the holder of the LSC expires, now next question will come, who will inherit?
Correct.
This has to be decided. I think the ownership has to be decided.
It has to be decided.
I think. So
Otherwise, my lord,
you look into it.
I will look into it.
Okay. This
Because-
was the act I was looking for.
One problem that would happen, my lord, if the ownership is not decided, because many times what happen is heirship certificate by itself has been used for mortgaging even by banks. So it will affect a lot of things, my lord, if it does not give ownership.
True. And they talk about also how the ownership is transferred. No transfer of any right, title or interest in any land shall be recognized by the administrator or the village council, and no person shall be deemed to be ex-operated from any liability due to the administrator or the village council by virtue of such transfer, unless such transfer is registered in the office of the administrator in the manner prescribed.
Yes.
So these transfer has to be administered,
Yes.
which you just said about the mortgage and all.
Yes. Has to be done properly. That
It has to be done properly. You may find more, but you have a look at it.
I will.
You ask your junior to
I will. We will.
look into all this. There are rules also. The Mizo district land and revenue rules. Something more might come.
Yes.
Because from where this whole concept of heirship had come, evolved.
It's an invention, my lord.
So, but somewhere, you
Somewhere.
see, because this shows
Yes.
the heritable right and all that,
Yes.
that the land settlement is heritable.
Yes.
Now, that question perhaps has to be decided in terms of the Mizo District Council Inheritance of Property Act,
Yes.
because that says who will inherit,
Yes.
isn't it? These all have to be looked together and read together. So, in between, there may be a link somewhere which I'm not getting. You might assist where the heirship certificate is mentioned. This is the same one. You have a copy? Do you want to see from here? There's an extra copy.
My lord, I'll just check the cover so that I can.
Give it to you. Done. If you want, you can borrow it if you don't have it. You borrow it, but yes, on Wednesday. Yes, Thursday. Keep this also inside, huh? And you had given me a photocopy of this, no? That inheritance. Yes, that I have. List again on Thursday. You inform the other side also. Let him be present, because then I can close it on Thursday. Otherwise, no, it will serve no purpose.
Yes.
I've been hearing this matter
Yes. Yes.
since last 1 week.
Yes. Yes, madam.
And this is the only point which is now involved,
Yes.
which will clear as which course
Yes.
this court should adopt.
Yes.
Isn't it?
Yes.
Of
Absolutely.
course, one in your favor and one against.